I wanted to focus in on some topics in the book. And then I was reviewing that today and seeing how, I think we'll get to it. The main topic I wanted to focus on. So this is part 2, and we're starting the chapter 10 on justice. And as I discussed last time or the time before, there's a dispute as to whether Jewish civil and procedural law, when I say procedural, I mean to say court procedure, whether that applies to Noahide law or not. So in other words, a lot of the corpus of Talmudic, particularly civil law, according to the second opinion, would apply to the nations as well. But under the first opinion, which is the baseline opinion, it doesn't. And the Noahide community has to construct its own procedures, and also has permission to, beyond simply enforcing the fact that, at the baseline, it just simply has to enforce that there's no theft, it has to enforce all the other 6 laws, which is which means that one shouldn't, as far as civil law means, one shouldn't take from another. One shouldn't, to a certain extent, adultery falls within a civil law to a certain extent. One shouldn't commit adultery and so on. And then you have, so that's the basic. In other words, that the courts should be instituted in order to warn the people and judge them for any infractions of the other 6. The other opinion is that, first of all, the Noahide courts don't create their own procedure in terms of how many judges, what type of witnesses are good enough, how does the court run, what procedures does it have. No, that all goes according to Jewish law, Talmudic law. It's incorporated. And similarly, a lot of the civil law, meaning in terms of theft, but this also kind of incorporates, again, a lot of the same opinions of views and conclusions in regarding how do we understand the Noahide law of theft. Does it include all Jewish law that's similar to theft? So that would mean laws in terms of the denying, withholding, and an object that has been in someone's possession as collateral, or they've been guarding it as a guardian. I forget how you call that in English, and I'm a lawyer, but I forgot what that's called in English. If you're retaining someone else's item, and then claim you never received it, or actually, I could say you claim it was, for example, you claim it was that it was stolen from you, and then it's later found that that wasn't true. Anyway, all different forms of theft. In other words, all different forms of theft, of fraud, also of torts, will be included. Under the first view, particularly laws of torts, meaning to say, if the ox gores the other his neighbor's ox, those laws don't apply under Noahide law according to the baseline view. Only actual theft, the taking of the property of another. But if your property causes harm to another, or other indirect causes of takings are not included under baseline Noahide law. Under the second view, the entire corpus of Jewish civil law is transferred onto Noahide law. So most of you already know this already, but I'm just reviewing it, particularly for you, Stephen. I think everyone else has heard this many times already. But so now we go on to another topic, which has to do with justice as active or as abstract on page 252. And that has to do with adjudication and enforcement. How far does the Noahide law go when we say that they have to appoint judges? Do they judge? Do they teach the law? Or are they enforcing it? Both. Does this law reflect the fact that the nations have to institute a government? What does this mean exactly? So let's take a look at this. We'll start from page 252. Justice as active and as abstract. I may need some help reading this. Let's see how it goes. See if my voice holds up. Justice, except perhaps in the most perfect and ideal utopian of societies, needs not only a court and judicial system to apply the law, but also employees of the state who enforce it, right? Okay. The police and perhaps even the armed forces in extreme circumstances, when they are called for this purpose, and those who carry out punishment and detention have this role. They are all agents of the executive power of the state, variously symbolized in law as king or government. So in other words, in centuries gone by, in earlier times, the executive power was vested in a king and possibly even the judicial power. Now it's in the government and different executive, it's officially called an executive branch, right? Prime Minister, President, so on. So this power of the state has the quality of action, which drives, maintains, and where necessary restores social order in accordance with law. Justice needs the auxiliary of enforcement. So in other words, for justice to be effective, it has to have enforcement. Otherwise, it's not effective. So I think what he's implying here is that within the commandment to create, institute a system of justice, enforcement must be part and parcel of this commandment. It's just logical. It's a logical conclusion that we have to draw. Otherwise, it's not effective. To have an academic court that renders decisions which nobody needs to listen to is pointless. And specifically because we have an understanding that Noahide law has to be exercised and exist in situations where the society really needs to be reformed and strict justice needs to be meted out to knock the society into shape. In other words, there's an understanding that Noahide law may need to be instituted where it doesn't previously exist and people need to be taught. There's an understanding that that's the case. Now, remember what Maimonides says is that Moses was instructed by God to teach and enforce the Noahide laws among the nations. So clearly, it's also going to be a part. And if Moses would have brought the people into the land, and if the Messianic age would have happened immediately, I guess basically saying if Moses would have been the Messiah, I guess, or however that would have played out, but Moses would have enforced by force to a certain extent Noahide law on other nations. And it actually, I don't know if you guys remember, I know who was with me back years ago where we studied some Psalms, some Tehillim, and we learned that King David, as he vanquished the Philistines, there are commentaries that say that he imposed Noahide law on the Gentile nations that he subdued. So yeah, there is that concept. It's kind of a little bit similar to colonization of the European powers in what they call third world countries and so on, where they may have, although it was forceful conquest, they may have raised certain standards or brought in at least certain Western practices into those countries and imposed them on those countries, right? It's very much the British, right? It's very much the British model. I know that much. Whether it's in India, different areas in Africa, where else would we say that was the case? I guess even in Palestine, I guess to a certain extent. Yeah, but I mean, most famously, I guess, in places like India and I guess other areas of Arabia. I don't know to what extent how successful they were there. Anyhow, back to this topic. So it's a similar idea that there is a place for that, and there may be a situation for that, and certainly there's an understanding that historically, with the flood and so on, and with the deterioration of many of the 70 nations in different various ways, there's going to be a need for enforcement. There's going to be a need where many within that society, maybe not the righteous and pious among the Gentiles, but there'll be a need for force to enforce Noahide law and to knock people into shape through deterrent, through the threat of penal punishment, whether, and obviously that's also, we discussed in the past, one of the reasons why Noahide law permits, and in the simple terms, prescribes capital punishment for its crimes, for violation of the 7 laws. And we said then that in various circumstances, it may not have to be always meted out, but it's certainly within the license of the monarch, or within the judicial and executive branch, to mete out capital punishment for violation of any of the 7 laws. Anyway, I don't want to get back to that. That's a whole discussion about that. But that's the basic fact, is that each one of them is a capital offense. And that again brings out the fact that we want to, the Torah, God is seeking to, if necessary by force and through very powerful deterrent, make that these 7 laws, these 6, or even, I guess, including the 7th, are taboo, that they're absolute no-nos. That's really what happens when you say that a moral crime is punishable by death. That's poison. You can't touch that. You can't go there. It's an absolute no, right? If you think about it, it closes a question. In other words, what I'm saying psychologically is a certain advantage of having a crime being a capital punishment. And we see it in our own societies right now. When a crime is not a capital punishment, there are those people who are going to say, I'm okay with going to prison. That's not a deterrent for me. I will commit this crime. I'll go to prison. That's okay. But nobody wants to die. I mean, although there maybe is a very small minority that are suicidal, but generally speaking, 99% of the population want to live. Okay? So, so having it as a capital crime, it sounds extremely harsh, but it's also a tremendous gift of kindness, because it creates a taboo in which, when it's enforced in a small amount, just maybe some examples will be needed, the rest of society begins to understand, and very quickly you change the culture very, very quickly as it becomes adopted, and people understand and take it for granted that these things are just are taboos that cannot be done, period. And that's that. I guess maybe the last thing that's remained of that in our society is murder. Where people understand that's a violation of nature, that's something that a human being should absolutely not do. There isn't really much else that in modern society is an absolute taboo. So I think the idea of the Noahide law, in terms of what it seeks to accomplish, at least in a rational perspective, by meting out capital punishment, is create that taboo. We said last time also, I said I wasn't going to do this, but I guess I am, is that also that all the punishments, divine punishments, also reflect atonement. And if it's a capital punishment, that means that for the Noahide, each one of these are extremely severe, meaning to say that they spiritually bring a spiritual death to the person that can be undone by a physical death. In other words, that because for the Noahide, all these laws are fundamental to the very purpose of their existence, and these laws are why they're here on earth, and to keep them are why they're here and why their soul is brought down into this world. And so violating any of them is an extremely serious break from their divine connection. And the way to correct that, again, if it's done intentionally and rebelliously, with intent and malice, is this punishment. Anyway, I mean, the truth is, what I said about intent and malice, is not the simple understanding, but is based on things we saw in this book, that if someone is not educated in society that's familiar with these laws, then they're not guilty of a capital crime, and they need to be taught. That's what we learned. Actually, I think it's the only place I've seen it, is here in this book, where he brings out this point where the course is rational and sensible. All right, anyway, let's get back to the point we're making here, because I got off course. But the reason why I got off course is the point that I'm trying to bring out, is that the structure of the Noahide law it takes into account that we're dealing with a young society that that is wild. In other words, there's an assumption that Noahide law may have to deal with a society that's in chaos. And it's given the power of coercion and force in order to restore order. And that's implicit and intrinsic to Noahide law. And so it's given, so the courts, and within the seventh law of instituting courts, they're vested with a tremendous amount of power. Good? Understand? Questions? Comments? Make sense? It's a requirement. If you think about, it's funny, I was thinking about this just today and how lucky we are in a certain sense. I mean, think how we would be if we lived in a society that didn't keep many of the Noahide laws. Law and order. Some of it is just basic law and order. Some of it is social order that we've lost to a great extent in terms of familial relationships and those type of taboos. And that's an extreme danger we're facing right now in the West. But at least in terms of violent crimes and to a certain extent, financial crimes, there's a certain amount of strong deterrent. We have a very strong police system. And, so we have basically, although I think that it's really become a lot weaker than it used to be, to a certain extent of law and order. Anyway, there's a lot to talk about that. But the point is we have to thank God. And as it says in Ethics of the Fathers, without a government, a man could swallow his friend whole. Without government, there's chaos, there's terrible violence and bloodshed, because the worst of us overpower the better of us in that type of society. A barbaric society, the worst, the murderers, the thieves, the rapists, etc., they run rampant. And so the first thing that we need is a government, a monarch, an executive, and a judicial branch that gets that under control. And then we can start talking about also the other Noahide laws and start knocking society back into shape. And that's really where there's an understanding that Noahide law may have to face that very, very, very often. Okay, next paragraph. At the same time, and more primarily, justice is not only action, but also judgment. As such, it is distinct from the actual enforcement of the law. So in other words, so we have to try to create a system in which there's an enforcement body. So in other words, what we're saying is the first part of this law to institute courts of justice is we have to have a government. That means that Noahides, the nations of the world, have to get together and form some type of governing system. They have to come together and create a police force and a governmental force to keep law and order. That's the first thing. The second thing is they have to study the Noahide law, know it, educate upon it, and then they have to adjudicate on it. That means that they have to deal with litigants who come before them with questions of Noahide law, and also punish, in terms of penal law, those who are violators. So that's what we're going to say. So those are the two things. We just first discussed paragraph 1 about the enforcement aspect, which is just more the creation of an orderly system. And the second thing is the knowledge that you have to have a judicial body that's very, very familiar and educated in the Noahide law, then they can answer questions about it and judge the people, disputes, and penalize and issue rulings about Noahide law. Major historical issue has been if and when the judging function of justice must be separate from the enforcing function required for justice. So these two powers, the enforcement power, the police power, and the adjudicational power, are they together or separate? Right? So in modern times, this question was raised by the idea of an independent judiciary separate from the king. Nowadays, the executive branch of government, who previously also had a judicial function. Noahide law stipulates that judges should be appointed, but does not rule out the possibility that the executive, monarch, president, or prime minister might also participate in the judicial function. Okay, so under Noahide law, we don't have a requirement for separate branches of government as the democratic or republic system requires or envisions. You don't have to have that. You can have that. You don't have to. Now, in that case, I'm now on page 253. In that case, which is most likely to occur in the two extremes of social disorder in the person of a truly great leader like Solomon. So in other words, what he's saying now, when do we have a situation in which both powers are vested in the same person? So what we're saying is that's usually in two situations which are really opposite and diametrically opposed. One is in a case of social disorder and breakdown. In that case, martial law, right? We don't have time to have a complex and long, drawn-out judicial system. We have the same people that enforce, they judge, they adjudicate quickly, and they mete out punishment quickly to knock things, as I keep using that slang, in order to knock things into shape, meaning in order to restore order. The other case is just the opposite, in which you have a king that is so enlightened and his legitimacy is so strong, and the concern for corruption is so low that he can embody both branches. So just the opposite. So you have a very interesting situation. You have a combined governmental function which operates at both ends of the extreme, in the best of times and the worst of times. Okay? Now, I'm just curious. So interestingly enough, so far he hasn't cited to any sources, except for the fact that we're citing to the biblical story of King Solomon, that we know that he did both. The Talmud also says that King David also did both, that he also judged, that he would judge cases of, particularly it talks about how he took pleasure in deciding cases related to women and their menstruation and when they would be permitted under Jewish law to again cohabitate with their husbands, as we know that a menstruant is not permitted to her husband, has to purify herself. Those are familiar with those biblical passages. But that's only a law for Jews. That's not a law for the children of Noah. In any event, the point is simply we have situations in which a king also judges, but those are in the best of times. So in that case, the requirement is that the executive leader practice proper judgment as distinct from exercising regular executive functions. So in other words, you can have a situation in which a king metes out justice without adjudication, right? In other words, if you have severe social disorder, there may be situations in which the king may have the military. I mean, it's not the way things are done, right, anymore, generally speaking, but they may have them if there's social breakdown and there's martial law and there's violent rioting, then the military may execute people on the streets. They may shoot down violent people in the streets, right? We generally don't have that, thank God, but if that might occur. I mean, actually, we do have it in cases of the police, right? Even today, if the police have to break into a home with their armed suspects, they often end up killing the suspects right there. So that's a form of the executive and police branch sort of, quote, adjudicating. They're not adjudicating, but they're meting out a punishment on the spot. I mean, you can say that it's in self-defense, and that might be an argument, but from another perspective, there simply is no time for any type of adjudication because of the law, because of their fear for the life, and they're simply carrying out an execution, right there. That's another possible way to look at it. Okay, but what he's saying here is that when we say that the king or the executive is carrying out a judicial function, that means the full judicial function. That meaning that the king is referencing to the law and following the rule of law in order to adjudicate, matters of law and dispute. It is more practical, common, and generally desirable that the functions of executive government and judgment be vested in distinct persons and separate institutions. But this is not an invariably principle prescribed in Noahide law. There must be courts, but it is open as to whether or not executive leaders of the state may participate. So there's differences of opinion whether they have to be, the executive can participate or not. There's also another question. Maybe we don't need a king. Maybe all we need is maybe their primary function is a judge, and the judge also has police force. In other words, that the judge reviews the facts and then issues a decree, issues a certain judgment, and then orders the police or the army, but generally the police, to then execute his judgment. Who is to say that we have an executive branch at all? There seems to be, though, some assumption that we do, that for a government to run, generally there's some king, there's some, parliament, there's some council, and usually at least one monarch type figure, president, executive, prime minister, that is also been appointed. Okay, so far not that complicated, right? Well, familiar, modern, a lot of it pretty modern topics, nothing really out there. Okay, next paragraph. The question of the relationship between the enforcing and judging aspects of justice arises in a situation where society breaks down. All right, this is what I was talking about. The relationship between enforcement and judging comes comes to the fore when society breaks down, right? This breakdown can occur either because there is no state apparatus and effective control, or because the state is itself corrupt and does not enforce rigorous justice in its own personnel and other citizens. The question then is there a personal obligation on the individual who sees justice to act to restore and implement it? Or do we say that justice does not apply in a state of nature to which society reverts when society breaks down? And justice can only properly exist in when there is social order with functioning collective institutions of justice. This is a fascinating question. This is kind of a philosophical question, right? So he's asking, this law that you have to institute courts, what does it really mean? Does it mean that, is that law imposed on the individual Noahide, individual, non-Jew, that he has to, every individual of the nations themselves has to look to it to make sure that the laws are enforced, or it's only when there's a governmental body? So what do we say? Any thoughts, comments?